Thank you for coming back. I hope you enjoyed your quick break. We've decided to slightly rearrange the panel to speak one at a time so that you can hear each speaker, but at the end, if we have time, we'll kind of gather up and face the audience. But our speakers are here, so we'll get started on this next panel. This panel is on biodiversity, oceans, and water security. We will still probably end right around noon, and let me give you a little bit of information about what's going to happen during the noon break. We actually have about an hour and a half for lunch today, and maybe we'll cut into it for a few minutes. But we have three really special things happening. First, lunch. We definitely have lunch for the speakers. I don't think we have lunch for the members of the public, and students, your lunch is coming. Well-earned lunch. But all of you are welcome to join two tours that will be giving during the lunchtime. So we'll eat for about 15 minutes or half an hour. And then downstairs there will be two wonderful people. Kavika Case, who's one of our students, who will be giving a 20-minute walking tour of this Capitol District, which is just across the street. So you have to cross one sidewalk, and you'll get to see Iolani Palace, the state capitol, and it'll be lovely to stretch your legs. So at about, I'll let you know when he's leaving. So he'll be right downstairs in the rotunda. And also Keahi Davis, who you met this morning from the Judicial History Center. If you'd like to tour the Judicial History Center downstairs, which is fabulous, you can just do a nice walking around tour of the Judicial History Center. So we're very, very fortunate. So you can tour outside, tour inside, or just chat during lunch. So I hope that's all clear. And then we'll reconvene. Where's Justice McKenna, my timekeeper? We'll reconvene at 1:30. So, all right, let me speak for just a second about an overview of the panel. So first we'll have, after I speak, my wonderful co-chair, Ambassador Lyons from the East-West Center, and we're so happy to have her as part of this panel. So she'll speak for a few minutes to share her perspective about her experiences in the Pacific and now with the East-West Center. And then Chief Justice Lorenzetti, it's such a pleasure to have you here. He will be next for about 15 or 20 minutes. Judge Kobayashi from our federal court, we're so happy you're here. And then with some arm twisting and some gentle persuasion, we have the pleasure of having Chief Justice Rhys Hodge from the Virgin Islands speaking. So let me give a quick overview of three things. Global to local. Global. Many of you in the room know about the World Commission on Environmental Law. The chair, Justice Benjamin, is sitting there. I am the fortunate deputy chair of the commission, and we have many members in the room. If WCEL members can raise their hand, I know. Yeah, look at that. It's fantastic. So if you are an attorney and are interested to see any of us, we are happy to have you as part of this growing family. The World Commission on Environmental Law is one of the partners for today's event. And we have two huge conferences coming up. I just want to give you a little insight about. The next one is the World Environmental Law Congress. And we are working very hard. It will be in Rio de Janeiro, thanks to Justice Benjamin. And it is actually a full week. I think we're now calling it the Super Week of Environmental Law with 6 different events, including, where's Andy, our friends from UNEP, Organization of American States, Claudia, and others. So please let us know if you're interested in finding out more, but it's a full week of environmental law globally, gathering judges, academics, lawyers of all kinds. So that's very exciting, something that we're working very hard on. And Emily Gaskin, who's running around here somewhere, our executive officer for WCL, is working extremely hard on that. Then we will be going to Marseille in June for the World Conservation Congress, which was last here in Hawaii in 2016. So it's every 4 years for the International Union for the Conservation of Nature. Hawaii, they tell us, I think they're being nice, but it's also truthful. They say Hawaii was the most successful World Conservation Congress. A record number of people, record engagement, and I hope Hawaii has had a profound impact on this global organization. I feel it because Antonio and I are always at those meetings and we get a lot of constant aloha back. Next, let me talk briefly about the engagement of the law school. My colleagues David Foreman, Professor Malia Kutagawa, Professor Richard Walsgrove are here today, and also our other two environmental law faculty members, Professor Maxine Burkett, Professor Kukua Sproat, who's with the Kukuliao program, were actually invited to speak to the Conference of Chief Justices. So our environmental law program is very honored to be fully engaged along with our fabulous law students. Local. When we talk about biodiversity, oceans, and water security, I can't help think about where I live. I grew up in Santa Cruz, California, right on the ocean, going to the tide pools, which are now fairly decimated. I'm so fortunate to live on the North Shore. But you know, if you live here, the incredible erosion of that shoreline, King Nui, Sunset, Laniakea, those beaches, the highway's in trouble. So in our daily lives here in Hawaii, we see it. In the Virgin Islands, I know you see it. In other states, I know you see it. So these matters are incredibly urgent to our daily life, and the pace at which we must keep up is itself speeding up. So, not to put much pressure on all of you, but this is really important. And somebody said to me the other day, isn't it great that you're gathering to take action? That's a big step for judges, right? And so that's part of the symposium, is bridging that gap between thought, careful thought, and action. So that's why this engagement is so important. And with that, let me introduce Ambassador Lyons. Thank you.
I think that was me, Denise, who said, isn't it great y'all are getting together to take action? No pressure. So, have a day. Kia rana, whakalapalahi atu, talapalapa, Yahweh, Kasridie, Lisa Ulunaka, Ali, and Aloha. Because aloha, yeah, that's right, that's what we do here. Because so many of you have traveled a long, long way to be with us right here, here in Hawaii, and here in the heart of the Pacific Ocean. I thought it was fitting to greet you in some of the languages of the Pacific and to welcome you to the first high-level panel with a heart filled with aloha. E ngā mana, e ngā reo, e ngā iwi o te motu nei. Tēnā koutou, tēnā koutou, tēnā koutou katoa. I want to acknowledge the inherent dignity of all who are here today, and acknowledge the many cultures and voices and perspectives which you bring to this gathering. And finally, I pay respects to the people of this land. Tēnā koutou katoa. So in the country of my birth, Aotearoa, New Zealand, the indigenous Māori people have a ritual for when they meet new people or strangers. They recite something that you call a whakapapa, or a genealogy, and the intent is to share who you are so you can see what connections you may have, and essentially at the end of the process, you're no longer strangers. So in that spirit, g'day, I'm Karina. My name is Karina Rosa Singamasi Lamoya Lyons. You can just call me Karina. I'm a Samoan New Zealander, and I have been the Vice President at the East-West Centre here in Hawaii. I'm the Director of Research and the Director of the Pacific Islands Development Program for all of 6 months. But I have been running from the law my entire life. So like any correctly minded citizen of the world, I started my career as a barrister and solicitor at the High Court of New Zealand. But I started out as a mergers and acquisitions attorney. I was just waiting for the boos and hisses. Right, past it. I enjoyed a brief stint as a resource management lawyer, a brief stint on the Faculty of Law at the University of Auckland, but I spent most of my career as a diplomat. So I came to this part of the world when I was appointed as New Zealand's ambassador to Palau and to the Federated States of Micronesia and to the Republic of the Marshall Islands. And I was also posted here to Hawaii at one point as the Consul General and as New Zealand's envoy to US and Indo-Pacific Command. So pretty much spent most of my career being a security analyst. But when I came here to Hawaii, I realized the importance for me and my family and for my people that I pour all of my intellectual energy and aloha back into the Pacific. So 7 months ago, I retired as New Zealand's ambassador to this part of the world. I said goodbye to the mansion and kissed the staff goodbye, and said goodbye to business class travel. And then I came back here to work at the East West Centre with a personal agenda to prioritize the Pacific. And why the Pacific? So the people of the Pacific are on the front line in the battle against the effects of climate change. So in this part of the world where countries, most countries are small island developing states, they've collectively and individually named climate change as the #1 security threat. So not tension in the South China Sea, not the threat of nuclear war with North Korea, but climate change. As a former diplomat, I can tell you it makes for an interesting set of talking points when meeting with US government officials. So the Pacific Island Forum, which is the regional governance body here in the Pacific, so akin to the EU or ASEAN or CARICOM, it's made up of 18 members, including New Zealand and Australia. And I just wanted to read an excerpt that was tabled in 2018 when the 18 members of the Pacific Island Forum stated that through the assertion of our will and the voices of our Pacific peoples, we hereby declare as follows. We reaffirm that climate change remains the single greatest threat to the livelihood, security, and well-being of the peoples of the Pacific. So that's part of the formal agenda here in our part of the world. And it feels very urgent, and I have a whole bunch of personal stories, but what I've been moved by lately is the fires in Australia, which a lot of you I'm sure have seen on the news. It's really hard for me to fathom the extent of the damage and the impact that that's having on those families. Some of the recordings record flames of 170 meters, right? I'm not great with numbers. So 70-meter high flames. So the Sydney Opera House is 65 meters tall. And I've been reading about, I tried not to read it because it just makes me very sad, but I was thinking more in terms of the devastation of the land, and I was thinking a lot about the animals, but it's incredible to hear about the responsibility that individual citizens have taken. They've sent so they have a volunteer fire service of 70,000 people, and many families have taken upon themselves to send their children away, and then husbands and wives are staying to fight the fires. And you read about tragic stories of young men and women with small children who have given their lives in the service of their communities. And it's an extremely urgent but also mainstream conversation there about the real life and effects of climate change. And as I was reflecting on my personal experiences, they're not nearly as dire as that, I have to admit, until this point in my life has been mostly academic. When I was first travelling through the Marshall Islands as ambassador, my favourite breakfast nook was at the local hotel, and it was right by the seawall. And in my first year of my tenure, we would sit there in the mornings. And I noticed it was fairly robust, but it was just a little sort of alcove right by the seawall. And then in my second year of my posting there, it was sort of crumbling away. And then by my third year, it was completely gone. And that is the story of the Marshall Islands. It's a low-lying atoll. And the fascinating thing for them is they're just used to it. They have taken on this radical self-acceptance. Just before, I have 1,000 stories like that, but for you, what's relevant for you, I actually am quite optimistic. Despite my career in the Foreign Service, I believe that it is possible to make a difference. In fact, here in the Pacific, we're quite proud of a lot of our leaders for the impact they've made on the world stage. Prime Minister Jacinda Ardern, New Zealand, former President Hawai'i of the Marshall Islands, to name a couple. But the fact is it's not actually enough, and change is not coming fast enough. So we, citizens, real people in real life, need leaders like you, the esteemed members of the judiciary, to harness your power, to realise that this is the time, right now, to exert the influence that you bring to bear. We need you, intellectuals, and overachievers, who've given your life in pursuit of justice for your communities, including the natural and urban environments in which they reside. We need you to be even more bold. Now, originally I only had a few minutes to speak, but I may get the opportunity to ask some questions. The East West Center is a knowledge institute, so I crowdsourced questions to ask the panel. I'm the director of research, and the bulk of my research department are made up of environmental scientists, climate change scientists, from hydrologists to drought specialists. And so to conclude, I'm simply going to ask the questions, and I feel like this is the East West Center's mission to be a bridge between the East and the West, but also a bridge between peoples. So these are questions from scientists who know nothing about the law other than to recognize the immense power and agency that judges hold. So a few things they've said. They want to know, what do judges know about science? So how do you ensure that the nuances are conveyed from science to law, and what are the most appropriate processes, mechanisms, or criteria to utilize? They genuinely don't know. So the East West Center is an institute that likes to, is supposed to produce use-inspired research. So my scientists are asking me, what does that look like for the judiciary? How can we produce science in a way that can be accessed by incredibly busy people who are incredibly clever and smart, but are not necessarily environmentalists or subject matter experts? And that was, how do we make our scientific research be more directly policy relevant? And is that actually useful for judges who ultimately will decide? And I have a few more, but on that note, I can't wait to hear from the panel today. Kia ora.
Thank you very much. It's a great honor for me to be here. Thank you to the Supreme Court of Hawaii and the judiciary, and congratulations to Mike and Denise for the work and for the students, because it's a great event, and it's a great pleasure also to share this moment with my colleagues. I would like to share with you my experience at the Supreme Court of Argentina. We have the most important cases on water law. We have 4 important cases decided on water law. One is the Ricardo case, the Casa case, the Rio 12 case, and the other one is about glaciers with variable. In order to take into account our limited time, I just refer 2 of these cases with the brief reference to the facts and to the decision, but stressing some holdings, because I think it's important to show how it's challenging our notions about classical issues like jurisdictions, legal process, or complex remedies, and other substantial issues like the right to access to water or climate change. Well, the first case is the Atoll River case. The Atoll River originates in the Andes, in Argentina. It's fed by snow in the province of Mendoza. It extended for almost 1,800 kilometers and ended at the Colorado River after crossing La Pampa. In the beginning of the 20th century, the Atoll River began to see a reduction in flow due to a construction to a dam that caused serious drought in the northeast region of La Pampa province. It's another state. In the 21st century, the impact of global warming added a problem of a scarcity in Mendoza, situated near the big glacier, began to receive less water. Well, the case is very complex, but during the hearings at the Supreme Court, La Pampa alleged that it had been robbed of the Atul River, which led to an environmental catastrophe. And Mendoza, on the other hand, argued that it was unreasonable to ask the desert for water due to the 1970% of the territory nowadays is a desert. Well, the court in 1217 ruled that the province of Mendoza and the province of La Pampa, two states, together with the national government, federal government, must submit a work plan for the allocation of the water of the Atul River. They must cooperate and should consider technical alternatives with respect to the specific ecological characteristics of the river, the construction cost of the works, and their distribution among the three governments. There must also be provision for the users' benefits, the needs of neighborhood populations, the need to protect access to drinking water, participation of the general communities of the region, and productive economic activity. The ruling implies a change in the management of the river. The court ordered Mendoza, La Pampa, and the national government to come to an agreement to implement the plan and fund works to mitigate the certification and improve the efficiency of water uses. Well, one of the holdings, very important I think, because the court expressed that the human right to drinking water has been a major consideration. The court argued that the access to drinking water directly affects people's lives and health, meaning judges should protect it within the scope of collective rights. It is essential, therefore, to protect water so as to maintain nature's function as a system and its capacity for regeneration and resilience. I think this is a change or a broader interpretation of the right to access to water, because it's not only individual. In this case, the right to drinking water is specified in the right to a water flow that guarantee environmental restoration. This is not only individual, it's taking into account the system, the operation of the system. The other holding I think is important is consider the certification to be a significant legal issue. The court added that the fight against desertification also implies to focus on water supply and not just on water demand. This is a big issue on water cases. The focus on water supply is how to increase water supply and not only on water demand. This means it is necessary to identify possible supply sources with a wider reach covering the entire basin and affected regions. This is a different approach because the Atul River Basin is a comprehensive system which is reflected in the close interdependence among the various components of the water course. The course underlined that adoption the measures in general are not restricted to territorial jurisdictions, since environmental conflicts are not limited from political or jurisdictional divisions. This is another big issue, because usually the conflicts, environmental conflicts, exceed the political and jurisdictional divisions. The court underlined that the very concept of river basin is one of unity, in which a water cycle is understood as a whole. There are no winners or losers in this case. The court decision concerns a debate on the environmental approach. I think it's very important the way the court established a framework of interpretation of the conflict. In the other case, I would like to mention is Barry Gold. Barry Gold is realizing mining exploration in the Andes, and they requested before our court the declaration of unconstitutionality of law which established minimum requirement regimen for the preservation of the glaciers and periglaciers environment. It's a glacial law. The court said first that because Barry Gold invoked specific damages to their property, and the court said the dispute cannot be interpreted as a mere collision of subjective rights. In fact, the characterization of the environment as a collective good that belongs to the community of common use is a common use and indivisible. This is a common good, and it affects the legal process because the legal process is polycentric. The solution shall not be limited to solve the problem between two persons. It's a problem of nature, it's a problem of the system. It's a polycentric approach that challenges our classical view of the legal process as bilateral. It's a big change. The other important holding is that the solution shall not be limited to solve the past, but to promote a solution focused on future sustainability, which demands a decision that foresees the consequences derived from it. The court finally stated that the protection of the right entails modifying a perspective according to which the legal regulation of water has been based in an anthropocentric model. The legal paradigm which manages the regulation of water is ecocentric or systemic, and it does not only take into account private or state interests, but the system interest as established by the general environmental law. We have in Argentina a strong environmental law. Well, these two cases are the basis to think about a new paradigm on environmental law focused on water law. We must think about what was water law in the past. What did matter in the past? What did water mean for the law in the past? From Roman law until the 20th century, water was a passive object of regulation, a mere factual assumption, like Antonio said. The Roman distinguished between extra-commercial and in-commercial law. But during a long time, water was an object over which ownership may be exercised. In the public sphere, water was classified as a resource, while in the private domain it was deemed a property good. An analysis of public policy from historical perspectives show that most measures have been based on the protection of human health, not on water. The diagnosis and the solution were defined in detail with a manifestly anthropocentric and short-term perspective. Water adapted to the regulation and did not generate rules or regulatory microsystems. In private law, the protected legal good is ownership corresponding to the patrimony of the citizens and of the nascent industrial companies. In the public sector, public health is protected, which policies basically aim at combating epidemics caused by the consumption of contaminated water. Everything's changed nowadays. What is the meaning of water for the law today? The view of water has changed in recent years. As a result, we are in a period of transition. The anthropocentric ownership model is demonstrating shortcomings and exceeding its limits. There are certain aspects that are worth bearing in mind. First one, the awareness that water is a scarce resource. Second, increased demand from the use of drinking water. Third, reduced offer due to climate change and increased pollution. The phenomenon has made evident in many situations in the rivers. There are problems of pollution from the industrial waste in groundwater, in the seas. Well, it's a well-known problem. I limited my time. But you know that there are a lot of problems in different areas of law: seas, polar waters, groundwaters, lakes, streams. Nothing escapes the issue. On the other hand, the effects of climate change are increasingly evident and produce extra heat, and therefore more demand of water, while in other locations the desertification process is reducing supply. The problem is scarcity and conflicts. The issue of water is gaining global significance in such a way that it is no longer a mere passive factual assumption, but a subsystem that generates its own regulation and categories, as used to happen with the case of the land. Water is an environmental subsystem and a microgood that, when it is affected, it produces cyclical and systemic effects. Nowadays, we have a great phenomenon because law is generating rules and not a mere passive effect. Is the good protected? There have been increased water scarcity and increased demand. Furthermore, water has always functioned as a means to reduce human disease, where the proliferation of illness has been primarily caused by a lot of water or its pollution. Also, water has become essential to the consumer society structure, but on the other hand, consumption multiplies sources of pollution: household waste, industrial effluents, agrochemicals and pesticides, synthetic detergents, thermal pollution, and a lot of situations like this. The good has been stretched to a breaking point due to the ownership and the indiscriminate implementation of the use model. Consequently, it is no longer admissible to have a law that allows everybody to use water in any quantity and for any purpose. Hence, it will no longer be possible for water to be a mere factual assumption for subjective rights. but rather this must adapt to the function of the subsystem, recognizing its circular and systemic nature. It is time we think of the water problem in terms of scarcity and competitive interest that must be fairly reconciled. The classification as a collective good situated in the social sphere also entails a replacement of the anthropocentric ownership model. In order to understand the environment, and specifically water, a systemic perspective is required so as to examine the processes in their entirety, from the source, supplies, use, type of use, and recycling of water after use. This is the forest community consists in assembly of plants, animal, air, and water. We need a systemic approach, and I think the environmental rule of law must reflect this approach, and this is the framework we use in the Argentine Supreme Court. Thank you very much.
Aloha kako, welcome everyone to this great conference, and mahalo to all of the organizers for inviting me. When I was asked to speak, my name is Leslie Kobayashi, and I'm one of the federal court judges. I'm a trial court judge, and many of my colleagues have been confronted throughout the country with issues of environmental proportion. I myself have not. So when I was asked by Justice Wilson to speak, it reminded me of a children's program I used to watch with my children, who are now teenagers and college students, called Sesame Street, that the national television, public television puts on. And they had this one segment where they taught children how to compare and contrast. And so they showed like 3 pictures of traffic signs and then a picture of an orange. And then the children on the program would sing a song, and one of the phrases was, "One of these things is not like the other." So that's me. I have no expertise or any experience with environmental law and other decisions. But Justice Wilson is like a Jedi Knight. And when he talks to you and you say, you know, I don't know, I have not decided great cases involving environmental law, and you want me to speak to this whole conference of experts and people with, who have dedicated their lives to these issues, and these are really big thoughts. He sort of waves his hand over you and says, "You will speak at this conference." So that's why I'm here today. So you may have the next 10 minutes or so listening to just my thoughts, and that's all they are. But of course he said, I'll give you cases and you can read them and take them. So that's what I did. It's 9th Circuit cases, 10th Circuit case, and so I've come to 2 great conclusions, and I just offer them to you today with all the humility and with forewarning that I have absolutely no expertise in this area. And the first observation or conclusion I came to which my sarcastic teenager would respond, duh, is that climate change is, of course, the greatest threat of catastrophic proportion to life on this planet. And the second conclusion I came to is that our traditional legal paradigm, as Justice Lorenzetti mentioned, completely fails. It's completely irrelevant. So the cases I looked at talked about standing, they talked about federal jurisdiction, they talked about federal common law versus regulatory schemes such as the Clean Water Act or Clean Air Act. And what I've concluded is that this climate change and its impact and the various harms that it's imposing on society are of such a unique and global nature that a new paradigm and analysis has to be constructed. And I was struck by the similarity that we are facing in an area that I know a little bit more about, which would be the Fourth Amendment of the United States Constitution, and the prohibition against warrantless search and seizure. So you think, well, what does that have to do with climate change? But what we're facing in the federal courts, they were facing that our forefathers in the middle and late 18th century, when faced by an oppressive government, the British government and monarchy, would go into their homes and search and take things, private papers, arms, and so forth. They felt so strongly about it that they created within the U.S. Constitution the Fourth Amendment ban against warrantless search and seizures of certain types of areas. And that would be your home, what they called your curtilage, your private papers, so that you could have private thoughts, even if they were such a rebellious or seditious nature, that those would be private and the king could not take them unless they had a warrant and had to follow certain legal procedures. And so fast forward to the 21st century where we're faced with these same issues, but the landscape has changed greatly because each of us now carry with us a computer. We carry with us on our bodies a personal tracking device that will show where we are every second of every day. We carry with us all of our medical and financial information, and we carry one of these. Is it a file cabinet? Is it a desk in our home? Does it matter if it's found on our person or someplace we control or in someplace else that we don't control? These are issues our forefathers could not have thought of because the technology of a smartphone just wasn't within even the realm of any kind of fantasy that they could have thought of. And what we're finding in search and seizure is that we cannot apply the old paradigm. We can't say to this new technology, well, it's kind of like a desk. It's kind of like the doctor's office that you give him personal or her personal information about yourself. We have to now think about the fact that this thing that we carry can show where we were 6 months ago when allegedly we're committing some sort of drug conspiracy or some sort of plot to overthrow the government. So courts have started to struggle with this, but why they can do that is because we can look at it in a body of law that supports and analyzes an important constitutional right and a right to privacy. So we have a construct, even though we can't apply the same old analyses. So to this new issue, this global impact of such catastrophic proportions, clearly the old legal paradigm, does the Clean Water Act cover it? Does the Clean Air Act cover it? Do we apply federal common law? Is there jurisdiction even to be in federal court? We really can't apply that. So what is our way forward? I don't really know. Is it that it should be a legislative regulatory scheme that should then apply to these new and unique environmental issues that have come up? Should it be the courts that create a new analysis, accepting jurisdiction because of the tremendous impact? And we should view it within the lens of a constitutional right to have these environmental issues addressed. Or is it something that should be done in a global international format? Perhaps even drawing upon indigenous peoples' philosophical impressions and analyses of the rights of the land and the water itself. I don't know, but I'm thinking maybe yes to all of the above. And so that's why it's important that gatherings such as this occur and the exchange of ideas and experiences are done within colleagues who have this kind of multidisciplinary background because it is not an isolated issue. And what is happening in Australia is tragic, and it's going to be clearly a demarcation of an Australia before and after. And the after of Australia is never going to be the same. And then we feel badly for Australia, but really what we're seeing is foretelling the future for all of us, for everywhere that we live. So it can't be something that we think, poor Australia, let's send money, let's send firefighters. We have to think, how are we going to handle it when it happens on our shores? What can we do now to address it in my particular arena through law, but in all the other aspects, because it is going to take, I believe, an interdisciplinary approach, law being only one facet of that. And so I appreciate the scientists that are asking these questions. And I say, just like we are grappling with this whole idea of technology and what it means to impact all of our rights of privacy, just like you see Facebook being called to Congress to answer questions and understanding, so must we address this epic catastrophe that is unfolding before us, that is impacting environmental issues. And so I thank all of you for your interest, your expertise, and your advocacy in attending things like this and having such strong science-based approach to this issue, because that's the only way that we are going to be able to hopefully take some sort of measure on a scientific, legal, and social and philosophical front to fight this impending doom that our planet is facing. So I thank you for your time. I've learned so much already, and I thank Justice Wilson for inviting me. I didn't add anything to the discussion, but I've certainly learned. And you, as always, are an irritant. But irritation, so I appreciate all of you. Thank you very much.
We do. And it's beautiful.
Good morning. I was last night. I think about whether I would say a few words today, and then this morning we've got to do it. So I don't have anything prepared. I'll just tell you, my name is Rhys, Hodge, Chief Justice of the Virgin Islands, the United States Virgin Islands. I've been the Chief Justice now for 13 years. Amongst the Conference of Chief Justices, I think I am the 5th most senior Chief Justice. I think Paul is 1 year ahead of me. Not a year, he was like a few months ahead of me. So I've seen a lot of chiefs come through. There was talk earlier of Chief Justice Richardson, for whom the law school is named after. He was president of the Conference of Chief Justices, and was the president when the conference, when the National Center for State Courts was created. And he's always been associated with that. And once you're a president of the conference, you're always a member. You can always attend, even if you're not a Chief Justice. And Chief Richardson always attended. I saw him several times, and very lovely person. So I decided I would say a few words. The Virgin Islands is similar to Hawaii. It's basically 3 major islands and then a smaller island that's inhabited, and then a lot of uninhabited islands. It was purchased from Denmark by the United States in 1917 for $25 million in gold. There are some plots of land right now that you couldn't buy for $25 million. But a part of the treaty, which I don't think a lot of people recognize, that in addition to the $25 million, Denmark required the United States to surrender any rights that it may have to Greenland. So recently when the president was trying to purchase Greenland, I don't know if anyone ever looked at the treaty and its white papers to realize that. But the Virgin Islands, it is the United States territory, so when it was purchased, all of it was owned by the United States government. Then it was first administered by the Navy in 1936, I believe, when you had the First Organic Act, and there was an appointed governor by the President of the United States, confirmed by the Senate. That went on until 1970, when it was the first elected governor. And shortly thereafter, the United States conveyed the submerged lands to the territory to the government of the Virgin Islands to be held in trust for the people of the Virgin Islands. And I say all this, I know I'm having enough time, but when under the treaty, there was a company that the Danish basically did all its shipping business called West Indian Company. And in the treaty, it reserved to the West Indian Company the right to develop the harbor in St. Thomas. They had already built the dock where the cruise ships docked. But they had the right to actually develop the entire harbor. They did nothing for over 60 years. And then all of a sudden they put in a plan to really fill in the harbor, dredge, submerge. And of course, people were up in arms, you can't do this. And of course, they had this treaty right. But the local government, we have a very strict coastal zone management, and this you need to have a coastal zone management permit to develop this harbor. And they said, no, we have a treaty right. We got this long before you even had a coastal zone management. So they went to court, the federal court, and in the process, the government settled. They made them reduce the plan of land, and they agreed that they would have the right to develop some of it. Of course, they did nothing for another 4 or 5 years. And when they did start to develop, the people got up in arms. It was going to block out the entire beach where fishermen pulled up the boats. And so they filed suits again against the government for breaching the agreement, the settlement agreement. And the governor directed the Attorney General not to defend the case because we had an agreement. They named the legislature as a party because the legislature had passed a law saying this project must have a coastal zone permit, which was a violation. Anyway, since the governor wouldn't defend the suit, there was nobody to defend it, and the legislature decided to hire counsel, and they hired out private practice at the time, so I was appointed to represent the government, the legislature, to defend against this suit. I looked at it and said, look, this is a losing proposition, you cannot win. The President of the Senate said, well, our constituents wants us to defend this case, and we're going to do it. And we can make the argument that since the government conveyed, the U.S. government conveyed the property in trust to the people of the Virgin Islands, that somehow should affect the settlement. We went to court, and that was, the federal court threw that out immediately. But in the end, we appealed to the Third Circuit, the U.S. Court of Appeals for the Third Circuit, which has appellate jurisdiction. And although they affirmed, they actually set out the process and for the public trust doctrine and set out some guidelines that the government must do in order to preserve that trust for the people of the Virgin Islands. And it was good, at least we got that out of it. Last year, I participated in a global constitutionalism seminar that Yale University puts on every year. And last year, there was I think it's the legal effects of climate change, and we've had about 40 cases all over the world that dealt with legal climate issues, including the case that I think Antonio made reference to, where there was this river in Colombia or some of the South American countries, where the court actually found that the river itself had standing to sue. And of course I said, well, and the Citizens United is in the corporation, I don't see why they shouldn't. But anyway, and then there's this series of cases where the suits are brought on behalf of the children. And there, establishing that under the public trust doctrine, the government actually holds the environment and trust for them. And I think it was one case, the case out in Oregon, that refused to dismiss the case and set out this doctrine. I think there was one in Washington that said they didn't have standing, but there was this process, and I thought back to this case that we had where here we have an express grant of the submerged lands in trust to the people. And, you know, why wouldn't, you know, that same, this was by Congress to the Virgin Islands people. Every state must have the same grant and hold all these submerged lands and other environmental rights in trust for the people. And I think that is the theory that these youth cases have been doing. But it's, so I just thought of that, and since I was told I had like 5 minutes, but the Virgin Islands, like Hawaii, we have really seen the effects of climate change. And I think it would be, you know, folly to say that climate change does not have any impact. The Virgin Islands, I think, in 1929 had a hurricane. Didn't have another hurricane for 50 years. I think 1979 we had Hurricane Hugo, and then we had Hurricane Marilyn. And 2 years ago we had 2 Category 5 hurricanes within 10 days. We had Hurricane Irma, and then 10 days later Maria, which knocked out the Virgin Islands, knocked out Puerto Rico, and the effects. I was telling someone last night that my insurance bill is more than my mortgage. And the banks, when they finance, they actually collect that money as added onto the mortgage so that they will pay the insurance bill to make sure you have it. And with every storm, so it affects economically. And, you know, we can't hide it. We, of course, we're a tourist industry, and that's really our economy. At St. Croix, we have some oil refinery or something, but the tourist industry, St. Thomas, that beautiful harbor that they were going to fill in, I think is recognized as one of the most beautiful harbors anywhere in the Caribbean. I think maybe Grenada may have one that comes close, but you know, it's just amazing. We have the coral reefs, of course, snorkeling, diving. We've had, you know, we sunk ships and developed natural habitats, and the coral reefs, the bleaching, the dye. And last night, when Denise was asking me to speak, my wife, she was reading the local newspaper, and she said there was an article, and it says the National Park Service. One thing I should mention is that the National Park Service is very large in Virgin Islands. St. John, which I think is one of the most beautiful islands there is 75% of it is a national park. And beautiful beaches, underwater trails that are marked. You can swim, and it'll tell you what coral, what flora, what fish actually is swimming in the area. I don't know how they get that done. But there was this article that says the National Park Service embarks on a multi-year project to mitigate coral disease at Buck Island on St. Croix. That's a national park. It says the National Park Service, in collaboration with the Moat Marine Laboratory, is starting a multi-year research project to mitigate coral disease at the Buck Island monument. It goes on to say the objective of this field and laboratory-based project will be to test and implement various strategies for reducing the spread of and severity of coral disease. This work is being conducted in response to the multitude of coral diseases that continue to devastate coral reefs throughout the Caribbean, including the national parks of Florida and the U.S. Virgin Islands. It goes on and on, but it was just ironic that she heard Denise twisting my arm and she said, "Oh, he'll speak." And what am I going to speak about? She read that. But we have had it, we've passed laws that actually outlaw the use of certain sunscreens. You know, we don't have straws, we don't have plastic bags, and trying to protect the plant. But it comes at it's a trade-off, basically, because we have this tough environmental groups that object to every commercial project that's built, and we are the ones to protect the environment. In St. Thomas, for instance, we still have a building code that restricts the buildings to no more than 3 stories above the ground. You know, we will build into the hillside, so it's several stories before we reach the ground. But in any of the hotels, you will not see that concrete building structures in here. I don't want to call it concrete jungle because I think it's beautiful, but we try to. I was told last night that there used to be a policy here that you couldn't build higher than the tallest coconut tree, but obviously that's not what happened. So I just wanted to share the Virgin Islands. We have the same issues, and we're trying to cope like everything else to have sustainable development, but also protect the environment. And I think it's what it's going. Thank you.